All right, so we're on the record in docket 23-02349. That is the City of Lansing versus Rory Garnott. Will the parties please introduce themselves for the record? Mr. Gehring.
Thank you, Your Honor. Good morning. Joel Gehring, appearing on behalf of the City of Lansing.
Mr. Lee.
Good morning, Your Honor. Assistant Public Defender John Lee, appearing on behalf of Rory Garnett, who is in the courtroom and standing to my right.
And sir, you are Rory Garnett?
Yes, Honor.
Okay, thank you. This is the time set for a final pretrial in the matter. Mr. Gehring, how we proceed?
Well, as you know, Your Honor, this was an assault in a homeless shelter. The police record had indicated that Mr. Garnett was having a medical event at that time. He is now being compliant with his medical needs and requirements. That has been verified by the prosecutor's office. So we will go ahead and amend this charge to a breach of the peace at this time. I did reach out to the victim in this case and did not receive a response.
So this is amended to breach of the peace. Is that the civil infraction or the misdemeanor?
Civil infraction.
I think that's punishable by $150.
Yes,
Sounds right.
Let's double check that.
Yeah, I would double check that. See that.
$150. All right. So that's your understanding, Mr. Lee. The charge will be amended to the civil infraction of breach of the peace. It comes with a $150 fine, and you'll be accepting responsibility on behalf of your client.
Yes, Your Honor.
All right. All right. So, and Mr. Garnett, that's your understanding also. Is that correct? All right. I'm going to bring you back to. So, Mr. Lee, I'll bring it just we're working from the same material. This is for conduct on March 6, 2023 at 601 North Larch Street in the city of Lansing County. It is your admission today on behalf of your client that he was responsible for being in breach of the peace. Is that correct?
That is correct, Your Honor.
Okay. That comes with a $150 fine. Does your client need some time to make that payment to the city of Lansing?
He will be making payment today, Your Honor.
All right. So let's set it. We'll set payment to be made today. To City of Lansing. And that'll be, I'll put it by 4 o'clock. He can make any time before then. It'll be made today on August 27th. By 4 o'clock. Anything else for the record in 23-02349, Mr. Gehring?
Nothing, Your Honor. Thank you.
Mr. Lee.
Nothing further.
All right, Mr. Garnott, you're all set. You can make payment to the city of Lansing either online, by phone, or in person by today at 4. Okay, sir? All right, thank you. I see we have Mr. Merritt online.
We can go ahead and take care of that one.
All right. That is Mr. Denby. All right, so we're on the record. Mr. Merritt, we'll call your case with Mr. Denby in docket 24L28705151 and 24L28070152. Is the City of Lansing versus James Denby. Appearances for the record, Mr. Gehring.
Thank you, Judge Joel Gehring, appearing on behalf of the city.
Mr. Merritt.
Yeah, please court, Your Honor. Attorney Frank Merritt for the defendant, James Denby. We're appearing by Zoom, and Mr. Denby is with me at my office to my immediate left on the screen.
Thank you. And sir, you are James Denby, is that correct?
Yes, Your Honor.
You can hear me all right, Mr. Denby?
Yes.
All right, thank you. This is the time set for 2 tickets today. Mr. Gehring, how are we proceeding?
Well, Your Honor, as you know, this is a civil infraction situation with a failure to stop leaving a private drive, as well as a misdemeanor for failure to display ops. Mr. Denby does have some issues with his license, but he has obtained a moped license so that he can use that as his primary means of travel while he's sorting other things out. I personally was satisfied with that. So In speaking with Mr. Nara, we've agreed to drop the charge of the failure to display valid license, and Mr. Denby will plead to the failure to stop civil infraction.
And is that a fair statement, Mr. Narrett?
It's like they frozen.
Froze on us just a bit there. All right. He is frozen and he's
Now it's
left and he's going to come back, hopefully. So the reprieve is plea to the civil infraction, the plea, admit to the civil infraction, and then that's failed to display leaving is, what's that punishable by? Do you know?
failed to stop.
That 150, 130? I don't, it's a civil infraction.
Yeah.
1 second. I'm not pushing the right button.
I think it's a 135.
I think it's a 130, yeah.
Bus is the 220, but I don't see anything else.
135.
Okay. Here's Mr. Narrett. Let's admit now. All right, Mr. Narrett, we lost you there for a second, but you're back. Is that a fair statement to plead to the civil infraction and dismiss the misdemeanor?
Yes, sir, that is. My client will plead responsible to the civil infraction. And I apologize, I just lost my internet for a minute there.
No worries, no worries. All right, so that the plea to the civil infraction comes with a $135 fine, and you'll be admitting responsibility on behalf of your client, Mr. Narrett?
Yes, sir.
All right, so this is for conduct from a ticket. The ticket is L287015. And on East Kalamazoo Street in Pennsylvania on May 17, 2024. Do you admit responsibility for your client failing to stop or leave an alley or private drive?
Yes, sir.
All right. And does your client need some time to make the $135 payment to the city of Lansing?
Yeah, we talked about that. If we could have until September 13th, which is about 2 weeks, Your Honor.
All right. So we'll make it September 13th at 4 o'clock to make the $135 payment to the city of Lansing. That can be made online, in person, or at the window. And with that, the misdemeanor of 24L2870152 is dismissed pursuant to the plea negotiations. Is that correct, Mr. Gehring?
That is correct, Your Honor.
All right. Anything else for the record on either one of these files, 24L2870151 or 52, Mr. Gehring?
Nothing else, Your Honor.
Mr. Narrett?
Nothing further, Your Honor. Thank you very kindly.
All right, you're all set. Thank you for your appearance today.
You bet. Thanks, Judge.
have Levante Williams. And so is Duncan. It's Duncan. That is the City of Lansing versus Pearly King. Will the parties please introduce themselves for the record? Mr. Lee. Mr. Gehring.
Thank you, Your Honor. Attorney Joel Gehring, appearing on behalf of the city.
Mr. Lee.
Assistant Public Defender John Lee, appearing on behalf of Pearly King.
And ma'am, you are Pearly King, is that correct?
Yes, sir.
All right, thank you. This is the time set for a City of Lansing pretrial. Mr. Gehring, how are we proceeding?
Well, Your Honor, this was a failure to display license misdemeanor situation. We've had several adjournments. You'd indicated the last time that that was the last time. Ms. King has shown some progress with reinstatement fees. She's having a little bit of a snag with the birth certificate issue, which I can understand, having tried to obtain one of those myself. We've decided to go ahead and amend this to an interfering with traffic so that we can take care of that now.
And is that your understanding of Mr. Lee?
Yes, it is, Your Honor.
Okay, so we'll amend to interfering with traffic. That's a civil infraction.
Correct.
And is that $135 fine?
Yes.
I think that's $135 fine.
Interfering with traffic or impeding traffic?
Interfering with traffic. All right. All right. And you'll be accepting responsibility on behalf of your client, Mr. Lee.
Yes, Your Honor.
All right. So this is for ticket L283753 for conduct that occurred on February 22nd, 2024 in the city of Lansing on South Washington and West Edgewood Boulevard. And you are accepting responsibility on behalf of your client for interfering with traffic, the civil infraction. Is that correct, Mr. Lee?
That is correct, Your Honor.
All right. And does your client, that comes with a $135 fine, does your client need some time to make payment to the city of Lansing?
Yes, Your Honor. She requests 60 days.
All right. So 60 days out for Tuesday would be
October 28th.
October 28th, 2024, $135. Ma'am, that can be made in line made by phone, online, or in person. And you have 60 days to make that payment. So you could set up your own plan if you choose to. You could go there and, correct?
Will I get something in the mail?
You probably will not get anything in the mail more than we can give you the October 28th date that it's due. Yeah. Yeah. Yeah, it can be paid online, on phone, or by person. It's $135, and you could pay it earlier than that, or you could make your own payments as long as it's all paid by October 28th. Okay. All right. And so if you don't make the payment by October 28th, if it doesn't pay in full, you'll get into that show cause cycle, and you want to stay out of that cycle. Okay. All right. Anything else for the record? And 24 L2837531, Mr. Gehring.
Nothing, Your Honor.
Mr. Lee.
Nothing further, Your Honor.
All right. So all of it will be due by October 28th. All right, ma'am? All right. Thank you. That's all for the record in that file.
Thank you.
Mr. King, do you happen to have the traffic site for interfering with traffic? I am not finding it.
257.649.
Thank you, Mr. King.
You're welcome.
All right. One. And then Mr. Lee, you said you're ready on Mr. Williams,
Yes, Your Honor.
Levante Williams. All right, so we're on the record in docket 2401-661. That is the City of Lansing versus Levante Williams. Will the parties please introduce themselves for the record? Mr. Garrett.
Joel Garing, appearing on behalf of the city.
Mr. Lee.
Assistant Public Defender John Lee, appearing on behalf of Levante Williams.
And sir, you are Levante Williams, is that correct?
Yes,
And you can hear me all right, Mr. Williams?
yes, Your Honor.
All right, this is the time set for a pre-trial. Mr. Garing, how are we proceeding?
Well, Your Honor, we had discussed this previously. We are here on a failure to stop an ID after a property damage accident. I had requested that Mr. Williams look at taking a driver improvement course. He has one scheduled for about the middle of next month. We're hoping for an adjournment so that he can take that, and then we can kind of go from there.
All right, so you're seeking for 30 additional days compliance.
30 days work for you, John?
Yes.
30 days.
All right. So this is the second adjournment for compliance, but it is granted since Mr. Williams does have the road test to take. So 30 days adjournment for compliance purposes.
I think it's September 24th at 9:30.
So it'll be September 24th at 9:30. Mr. Williams, please keep in contact with your attorney, Mr. Lee. Provide any paperwork to him that needs to be advanced to the assistant city attorney. And we'll be back here on September 24th at 9:30. All right, sir?
Yes, Your Honor.
And you should get notice sent to your last known address, which is, I want to make sure we have the right, that is the Holmes Road address. Is that still a good
Correct.
address for you, sir?
Yes, Your Honor.
All right. All right. Anything else for the record in 2401-661, Mr. Garing?
Nothing for the city, Your Honor.
Mr. Lee.
Nothing further, Your Honor. Thank
All
you.
right. You're all set, Mr. Williams. Thank you for your appearance today.
No problem. Thank you, Your Honor.
Mr. De Leon or Mr. Duncan. Your pick, Mr. Lee.
Mr. De Leon will be great.
All right, Mr. De Leon, we'll call your case. You can come up here. All right, so we're on the record in docket 24L2877981, 82, and 83. That is the City of Lansing versus Juan De Leon. Will the parties please introduce themselves for the record? Mr. Garrett.
Thank you, Your Honor. Attorney Joel Garing on behalf of the city.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Juan De Leon.
And sir, you are Juan De Leon, is
Yes,
that
sir.
correct? Thank you. This is the time set for a City of Lansing pretrial. Mr. Garing, how are we proceeding?
Well, Your Honor, we are going to ask for an adjournment in this case. Mr. De Leon is going to begin the process of trying to get this license situation resolved. I'd like to give him some time to comply with that.
All right, and all right, let me, so Mr. Lee, is that your understanding?
Yes, Your Honor.
All right. So we're gonna start giving you 30 days for an adjournment to see how this works out. At the 30-day, well, Mr. Garing will have more information. I'll run the driving record to see why your license is suspended. Because the whole point here is to get your
Yeah.
license back. And licenses can be suspended for all kinds of reasons, right? For paying court costs, for having a bad driving record, and that may determine how fast it is to get your license back. But you understand the plan here. The plan is to get your license back. All right. So we'll grant the request for adjournment for 30 days. September 24th at 9:30. So we'll adjourn for 30 days to September 24th at 9:30. We're going to revisit this, make sure that you're doing things that you need to do. If this becomes you always have the criminal case, you always have the representation of Mr. Lee. But if this becomes a case where progress hasn't been made, then all the parties are going to know, okay? We're going to all know. Right now, Mr. De Leon, what we want to do is we want to make sure that you're making the right steps to get your license back. Okay, sir?
Okay.
All right. Anything else? So this is adjourned to September 24th at 9:30. Anything else for the record in dockets 24L2877988182 or 83, Mr. Gay?
Nothing further, Your Honor.
Mr. Lee. All right. You're all set, Mr. De Leon. Thank you for your
The
comments.
address, because I never got any
Oh, yeah,
paperwork.
yeah. We
from
want to
this
double
board.
check and
Oh,
make sure that.
make sure you have an updated address.
Yes, because I never received nothing. The only reason I found out I was going to court today, is I seen this voicemail.
All right, that's a good idea. Let's, we have the 223 Ash Ridge Mason.
Yes.
All right.
I never received nothing.
Okay.
Is that what you have? Let me check the computer to make sure.
Yes.
Okay, we have the 223 Ash Ridge Mission. So make sure you're getting all your mail there, okay?
Yeah, I never got this court date.
All right,
today.
yeah, it's important.
Given to at a rate.
Yeah, so for whatever reason, we have the right address, but make sure you're getting all your notification, okay? And you should get notice from my court officer right there, all right?
Thank you, sir.
Thank you. All right, you're all set, Mr. De Leon.
Have a wonderful day. Your
You
Honor.
too.
Good job.
Oh, yeah.
Mr. Duncan is online.
I do need to speak with him.
All right. All right, Mr. Duncan, I'm gonna put you in a breakout room with your attorney, Mr. Lee, and then we'll come out and put it on the record. All right, sir?
Okay.
All right. So I'm gonna go ahead and put you in room 1, and I'll put your attorney in room 1. I think you should get a prompt to go to room 1, and I'll put your lawyer in room 1 when he joins the breakout room.
Okay, I'm joining now. Thank you.
Okay, thank you. The civil, I figured it out that I just have to click on base and then it covers up that they both, because I used to move them over and I don't anymore. Mr. Lee, were you ready on Mr. Duncan?
Yes, we are, Your Honor.
All right. All right, so we're on the record in docket 24-01688. That is people of the city of Lansing versus James Duncan. Will the parties please introduce themselves for the record? Mr. Gehring.
Joel Gehring on behalf of the city, Your Honor.
Mr. Lee.
Assistant Public Defender John Lee appearing on behalf of James Lamar Duncan.
Thank you. And sir, you are James Duncan, is that correct?
Yes.
And you can hear me all right, Mr. Duncan?
Yes, I can.
All right, thank you. This is the time set for a pretrial, a City of Lansing pretrial. Mr. Gehring, how would you like to proceed today, or would you like to defer?
I will defer at this time, Your Honor.
Mr. Lee.
Your Honor, Mr. Duncan reports that he was unable to register for the highway safety seminar. He didn't know how to do it and was not provided any specific information to that effect. I have just now emailed him a link to the highway safety seminar registration webpage. He confirms that he did receive that email and is going to register forthwith. So we're asking the court for a short adjournment to allow him an opportunity to complete that class.
All right, Mr. Gehring, this would be a short adjournment to complete the class. This was originally adjourned on July 30th for compliance, and then we're set for August 27th. Do you have any objection to a short adjournment in this matter?
I'll leave it to your discretion, Your
All
Honor.
right, thank you. I will grant a short adjournment in this matter since we gave a previous adjournment on July 30th. And we will grant a 2-week adjournment. So Mr. Duncan, do whatever you're supposed to do in the next 2 weeks,
Yes, sir.
and we'll set it for adjournment at
September 10th at 9:30.
September 10th at 9:30. So we've set it for September 10th at 9:30 for compliance purposes. Anything else for the record in docket 24-01688, Mr. Gehring?
Nothing for the city, Your Honor.
Mr. Lee?
Nothing further, Your Honor.
All right, Mr. Duncan, we'll see you via Zoom on September 10th at 9:30. All right, sir?
Thank you. I appreciate it.
Okay, you're all set. Thank you for your appearance today.
All right.
And then, Mr. Lee, we do have some people in the courtroom.
That's Mr. Tino and Mr. Beaver.
Okay, so Teno is, I think that's yours, Mr. Lee, and Mr. Buford, right? Or Kosi Buford? So I think they're both public defender cases, Mr. Lee.
Yes, sir. I will be right down. Thank you so much.
All right, thank you. All right, Mr. Gearing, what case are we calling?
Yeah, that's what looks like Charles Randall Jackson, Your Honor.
All right. So we're on the record in docket 24-08151 and 24-01852. That is the City of Lansing versus Charles Jackson. Will the parties please introduce themselves for the record? Mr. Gearing.
Joel Gehring appearing on behalf of the city.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee appearing on behalf of Charles Jackson.
And sir, you are Charles Jackson, is that correct?
Yes, sir.
Thank you. This is the time set for a pretrial on both matters. Mr. Gearing, how we proceed?
Well, Your Honor, I am going to talk a little bit about this one. We have come to the conclusion that we will drop the furnishing false information and Mr. Jackson will plead to the no insurance. I normally would not be inclined to do that given Mr. Jackson's record. However, he is under specific supervision in this case. I guess it does have a tether at this time. I want him to be able to find a job, which means needing a license, and the furnishing false information would impede that. So despite those misgivings, I will go ahead and drop the furnishing false information if he will plead to the no insurance misdemeanor.
All right. And Mr. Lee, is that a fair statement?
Yes, Your Honor.
All right. And the no insurance is on it's a misdemeanor on a ticket. So may I inquire of your client of his advice of rights on the misdemeanor no insurance case?
Yes, you can, Your Honor.
It's looking for that oath of court officer. I found it. All right. So, Mr. Jackson, you understand you have the following jury trial rights, and I'll walk you through each one of those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty. You have the prosecutor prove beyond reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question those witnesses that are brought against you. You are represented today by Attorney John Lee, and he would be present to cross-examine any witnesses or contest any charges brought against you by the City of Lansing. Do you understand that, sir?
Yes, sir.
You have the right to have the court-ordered witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of anything that hasn't been placed on the record or threats that it was not your choice to plead guilty. You'd be giving up the right to appeal anything from a trial. Since you won't be having a trial, you'll be pleading to the no insurance misdemeanor in this file. Is it your wish today to waive your jury trial rights and plead guilty to the no insurance misdemeanor in this file? All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. I'm going to bring your attention back to June 16th, 2024 at the location of West Holmes Road, Berwick Drive in the city of Lansing. Were you operating a motor vehicle on West Holmes Road and Berwick Drive in the city of Lansing on June 16th, 2024? And were you operating that motor vehicle without insurance?
Yes, sir.
All right. Anything towards a factual basis, Mr. Garrett?
Nothing more, Your Honor.
Mr. Lee?
Nothing further, Your Honor.
All right. Is there any reason we shouldn't go to immediate sentencing, or did you want this reviewed by probation?
I would like it reviewed by probation.
All right. That was my inclination. So, all right. So you pled to the no insurance file. You're aware that no insurance, it's a 1 year, isn't it?
Yes, Your Honor.
So 1 year is the possible penalty is 1 year, and or is it 1,000 or 500?
That I don't have off the top of my head.
I don't remember if that's
I think
yet. And we're going to refer this to probation so they can look at it and decide what options are available to us at sentencing. Okay, sir. We're kind of aware with your case. And is there other supervision going on at this point in time?
That's my understanding.
All right, so, so we're gonna refer to probation. So you should go to the 5th floor and contact the probation. They're gonna either set up a date or today. They'll either set up a date, or if they have time today, they'll do it today. They'll ask you a bunch of questions and prepare a report for me. So we'll see what options are available to us at sentencing. All right, sir? All right, sentencing date of,
October 22nd at 1:30.
October
22nd.
22nd at 1:30. All right, so on docket 2401-851, we've set it for sentencing date on October 22nd at 1:30. You should go down to probation, make sure who you're contacting with, and they'll prepare a report for me. The file of furnishing false info will be dismissed upon successful plea and sentence of the no insurance file. That's 2401-852. Any questions of the plea or the review of probation of Mr. Garrett?
Nothing, Your Honor.
Mr. Lee?
Nothing further. Your Honor.
All right, Mr. Jackson, go down to the 5th floor and we'll see what options are available to us on the data sentencing. Okay. All right, thank you. All right, Mr. Lee, once the probation.
Right, I'm sorry.
Yeah, all right. Is that Mr. Jackson?
Patience, James, patience.
You might want to email probation. Tell him the stuff I was, just so he knows that.
yesterday.
All right, Ms. Davenport, we're ready on your hearing. So we're on the docket in 24-00736. And ma'am, you are Angela Davenport, is that correct?
Yes,
All right. This is the time set for show cause today. It's my understanding after looking at the computer, you have $500 left on your balance. Is that correct?
yes.
All right. So you made a large payment yesterday. Do you want to set a new plan up? It appears that there was some obstacles in doing the payment plan. But do you want to set up for that last $500, or do you want to set it for a date out that would be reasonable for you to make that payment?
Yeah, he had gave me until December to pay it
All
all
right.
off.
All right. So do you know what date in December he gave you until?
He nope, he just said it needed to be paid off before the end of December.
All right.
And I had came into some financial troubles. That's why I had made monthly payments. So when I could make a big payment, I did.
All right. So well, December the 31st would be a Tuesday afternoon.
I could have it paid before December 31st.
Oh, that's a holiday, isn't it? And the day before is Christmas Eve. So let's make it January. All right, now you're gonna have to help me because
January 2nd, please.
So let's set it for January 2nd, 2025, for you to pay the 500 balance to the city of Lansing. And we've set it out so you can make your own payment plan. If you can pay it all by 500, you can pay $100 next week and $100 the following month, as long as it's all paid by January 2nd. All right, ma'am?
Okay.
And so January 2nd is the date for the 500 balance, and the show cause will not be issued for your appearance. So you should be all set. All right, Ms. Davenport?
Okay, thank you.
Thank you. You're all set. Thank you for your appearance today.
Bye-bye.
This is Mr.
Those are running course.
This is Mr. Witt. All right, so we're on the record in docket 22 L2752482. That is City of Lansing versus Sarah Dombrowski. This is time set for a show cause hearing on a traffic ticket. How much is owed on this?
192.
So $192 is owed to the City of Lansing. This was set for 11 o'clock. It's now 11:19. And it would appear that the defendant has failed to appear for show cause, and a bench warrant and bond forfeiture is going to be issued. That's all for the record in 22 L2752482. All right, so we're on the record in docket 21-00339. That is the City of Lansing versus Ashley Hart. This is a show cause hearing for the amount of $924. 942. Did I say 924? 942. Would appear this was scheduled for 11 o'clock. It is now 11:21. Here the defendant has failed to appear for show cause hearing. I do not see Ashley Hart in the Zoom courtroom, physical courtroom, or waiting room. And a bench warrant and bond forfeiture is issued for fail to appear. And that's all for the record in 21-00339. All right, so we're on the record in docket 23-02336. That is City of Lansing versus Reginald Henderson. This is a show cause hearing for the amount of $150. This was scheduled for 11 o'clock. It is now 11:22. Appear that the defendants failed to appear for a show cause hearing. I do not see Mr. Henderson in the Zoom courtroom, physical courtroom. There's nobody by that name in the waiting room. So a bench warrant and bond forfeiture will be issued for fail to appear. That's all for the record, 23-02336. All right, Ms. Spitzley, you can unmute yourself.
Okay.
All right, so this is, we're on the record in docket 23 L2769733. That is the City of Lansing versus Victoria Spitzley. And ma'am, you are Victoria Spitzley, is that correct?
Yes.
All right. This is a show cause for a balance of $192 that you owe to the City of Lansing. Do you need some time to make that payment? We extended you to July 15th of 2024, and I still have a balance of $192. In order to avoid a warrant for your issuance for show cause, did you need some time to make that payment to the City of Lansing?
Yes, please.
All right. What would a reasonable time be for you to make that payment? And if I set it out sometime, you can kind of devise your own payment plan as long as it's all paid by that date.
Okay.
So what would be a reasonable time to extend the date to from this date, from August 27th?
September 25th.
September 25th. All right. That's about a month away. Let me give you, so September 25th would be, how are we looking on October 8th? Okay. That's 6 weeks out, I think. All right. All right. So I'm going to have a payment can be made to the City of Lansing by, I'm going to put it out to October 8th, 2024. That'll give you a couple more weeks than that September date to pay that entire balance of $192. And you can set your own plan. If it's not paid by that October 8th date, another show cause will be issued and you'll get right into the show cause cycle that you want to stay out of. All right, ma'am?
Yes, sir.
All right, so a payment of that $192 can be made to the City of Lansing at the counter, online, or by phone, all right?
Okay.
All right. Do you have anything else to ask of me, Ms. Spitzley?
No, I do not.
All right. So your date is October 8th, 2024. Thank you for your appearance today. You're all set.
Thank you.
You're welcome. All right, so we're on the record in docket 24L2845171 and 24L2845172. That is a City of Lansing versus Sharisa Lindsay. This was scheduled for 11 o'clock. It is now 11:28. I do not see Miss Lindsay in the Zoom courtroom, physical courtroom, or waiting room. It appears the defendant has failed to appear for the show cause hearing. There's a balance of 192 on 24L2845171 and a balance of 318 on 24L2845172. For fail to appear, the court will issue a bench warrant and bond forfeiture on both files. And that's all for the record in 24L28457171 and 24L28457172. All right, so what's your name, sir?
Remy Lewis.
Remy Lewis. All right, so we're on the record in docket 21L2645581 and 23L2811432. That is City of Lansing versus Remy Lewis. This is a show cause hearing. I have you having a balance due of $264 on one file and $222 on the second file. Let me check to make sure those right.
On the 21 file, he recently made a payment on August 13th. He owes $2.
All right, so that's on the 21 file. So that's pretty much been paid up.
And then on the 23, he owes $144. He also made a $100 payment on that case on August 13th.
All right, so on the 21 file, that's all but $1.
Two.
All but $2. So we'll dismiss remaining $2. And the file is, did I administratively close that file or?
Just waive it.
Okay. No, but
Yeah, you just say waive remaining balance.
waive
close
remaining.
file.
So on that file, I'm going to waive remaining balance. Close file. That was a $2 file. So what you're actually here on, so we'll put that one aside, is the $144 that are owed to the city of Lansing. And do you need some time to make that payment, sir?
Yes.
All right. Yes.
He has another file on a driver license suspended park with that he was sentenced to that he owes $425 and it's due on November 12th. I didn't know if he just wanted to send everything to collection, so he just had
Refer- yeah.
one file to worry about and one place to make a
Yeah.
payment.
That seems, so let's put the 144 balance with your driving while license suspended file.
Which is
And what's that number?
24-01927.
So, and we're going to refer it all to collections. So if you meet with City of Lansing collections on both files, they'll have your entire both files. They'll have the driving license suspended file. They'll have this no proof file, and then it'll be put in. It's going to be around $500. All right, so go to the window, and they should have both files.
I'm sending an email
Okay.
just for clarification purposes.
All right. And I'll refer them both to collection. So it's all in one area and all in one, and you've taken care of the show cause. All right, Mr. Lewis. All right. So go to the window and we're going to email them and we'll refer both files to collections. So you can address both the 24-01927 file and this $144 left on this file. All right, sir. You should be all set. Thank you.
All right, thank you.
James, tell me if you go into our extension drawer on 112 and actually, I'm sorry, on November 12th and actually pull it out and hand it to them. I know.
All right. And then let's go on. I think we can go on Brendan Carter.
Yep. Let me send. There we go.
Okay. And then we're 158 there. Kelly?
That's a really good action. Oh, pay attention to the numbers.
Or 150.
I show 150.
Yeah. So we're on the record in docket 22-03224R1, 22-03324, people of the state of Michigan versus Brendan Carter. This is set for show cause today on the amount of $150. I do not see Mr. Carter in the Zoom courtroom, physical courtroom, or waiting room. This was scheduled for 11:30. It is now 11:48. It would appear that Mr. Carter has failed to appear for the show cause hearing, and a bench warrant and bond forfeiture is issued. And that's all for the record in 22-03-224. There's Mr. Carter. And then we're on the record. And how much? All right, so we're on the record in docket 24-00872. That is People's City of Lansing versus Alberto Perez. This is the time set for a show cause hearing. It was scheduled for 11:30. It is now 11:49. It would appear that Mr. Perez has failed to appear for the show cause. I do not see Alberto Perez in the Zoom courtroom, physical courtroom, or waiting room. So it appears that the defendant has failed to appear for show cause hearing. This was set for a balance of $225, and a bench warrant and bond forfeiture is issued. And that's all for the record in docket 24-00872. on the record in docket 23008991. That is City of Lansing versus Woodside Meadows. This was initially a motion to set for show cause on today's date. When we set this, we didn't have an attorney for opposing side. I granted a motion to withdraw from the then attending attorney. So appearances for the record, Mr. Staples.
Matt Staples for the City of Lansing.
Joshua Appel here for defendant Woodside Meadows Apartments Owner LLC.
All right. All right, this is the time set for a show cause. I am in receipt of the defendant's brief in opposition to the motion for show cause, and I received it yesterday. But it does have plenty of attachments, and I had an opportunity to read it. But I don't know, Mr. Staples, you must have received this yesterday also, if not before.
I have received it and reviewed it.
All right, okay. So how are we proceeding today, Mr. Staples?
Your Honor, it's my understanding, and I guess the court may have information on this as well, that defendant has paid the $43,500 to the court, which was the main subject, obviously, of the civil contempt motion. The city did include reference to criminal contempt in the motion of vindicating the orders of the court. I will say, obviously, this is the second show cause we've now had on this file. Show cause has been necessary both times to get payment from Woodside, originally on the $14,250 and now on this sum. The city believes that does show to some extent a repeated failure to heed the orders of the court. Obviously, there were also 2 prior orders to bring 3 buildings into compliance. Neither of those were followed as well. So there has been some showing of continued non-compliance, but the city would leave that really at the court's discretion, as it is, the court's authority that would be being vindicated.
All right, so the city's, the indication is, and it was said in the brief, but we'll put it on the record. The amount paid thus far to, and I know that there was some confusion as to the city of Lansing's not exactly 54A, and then there were accounts and all these things that are none of the fault of the defendant on some level, but make sure. So what's the indication from the city as to what's been paid today?
So the city would state that all outstanding fines have been paid. The $43,000, I think $500, that was the subject of the civil portion of the show cause, has been paid by defendant, and he has proof that it was delivered to the court yesterday.
All right, so that's the $43,500, and then there was a $14,250.
That was previously paid directly to the city of Lansing.
So that's been so. The $14,250 was previously paid.
Correct.
So is there any outstanding balance other than what's been assessed at fines? And do you have a number of what's been assessed this far?
I believe that I don't have a number off the top of my head on the total that's been assessed this far, but I don't believe there's anything outstanding at this point. I believe the $43,500 was the outstanding $33,500 from the original judgment for all the properties being out of compliance, and then a $10,000 fine on top of that.
All right. And the $10,000 fine's been paid?
Yes, correct. That entire $43,500, I believe, was remitted yesterday.
All right. And so I checked the computer, and the computer still has an outstanding $14,250.
Correct. I think there's some confusion. I know defendant shares this confusion on
where that comes
several hearings ago. There was 14 or 15,000 essentially held in abeyance, and then the 14,250 that was to be put into escrow was then turned into a fine.
All right.
I think the parties were under the impression that was
covered.
Right.
All right. That's my understanding. All right. But I'm going to go back and look through each hearing just to see if what I ordered it matches up with the orders, but that is what I'm understanding. There is still an outstanding 14,250 balance that one was placed in escrow and one was a fine, and I think it just carried over into it. So, but I want to make sure of that. I want to make sure. So I'm going to go back and look at that. In regards to compliance with the apartments, what's the request of the city at this point?
So, Your Honor, at this point, there have been no further inspections by code enforcement. It's my understanding that some permits have been pulled and some trade inspections may have taken place. But at this point, none of the buildings have been passed into compliance, or I don't even believe inspections have been scheduled for that compliance. So the entire property would remain out of compliance at this point.
All right. And is the city seeking any further measures of compliance since they're out of compliance? And that's why we're here.
Right. Your Honor, I know previously we have done the 500 a property for a total of 33,500. I think at this point it's appropriate for the city to leave that number in the discretion of the court, given the amount of fines that have already been issued. I think obviously some amount of penalty would be warranted, given that this entire complex remains out of compliance after several rounds of financial sanction at this point, Your Honor. But I, again, will leave that to the discretion of the court.
And so that's what I've done. That's what we've done in the past. So that's what I've done in the past. I put $500 per property. We do have a new lawyer, Mr. Appel's here, and so we have a new party of doing a new party to do business with. Anything else, Mr. Staples, on behalf of the city?
I think that about covers it, Your Honor.
All right, Mr. Appel.
Hi, good afternoon, Your Honor. Before I get into anything else, if you would like, I do have the UPS proof of delivery of the payment. I don't know if you'd like a copy of that or not.
Sure. Let me add it to the file. So, but I also looked in, and that appears to be the case. Thank you, Mr.
Thank you, Your Honor. Well, I will keep this relatively brief. As you noted, Your Honor, I am new to the case, and I understand I'm walking into something where there's been at least a good chunk of history. So I believe I am up to speed on what's going on. I will just note that in terms of the city's request for criminal contempt, I don't think that's warranted. I won't repeat everything that's in my brief, as Your Honor said that you looked at it. I think that Mr. Staples, I at least hope, will attest that since my involvement both in this matter and in other litigation involving the Woodside, I've done my best, and like I said, I think he'll agree that I've tried to be fairly cooperative and get my client to get things progressing. And for example, the payment of this fine. I also was just telling opposing counsel that they recently hired a security company because I know a lot of the complaints about the property are about different potential security risks that are going on there. So we are trying to make progress. Also, in terms of these, something for in terms of a punishment, a criminal contempt, this is really not how my client intended these things to go. It's not as if everything is going great and they're just refusing to pay these fines. There are serious financial issues with the lender, who actually just recently filed an action in Eaton County Circuit Court for foreclosure and other counts. As you may know, the city has a pending action in the Western District of Michigan, but there's actually a hearing this Thursday to have a receiver appointed. So this is not an issue where someone's just doing something to flaunt the court's orders. This is, there are issues there beyond what, just some fines and things like that. So anything criminal to vindicate the court's authority, there's no reason. My client certainly respects the court's authority, and I guess I'll leave it at that, Your Honor.
All right. Well, we have until we get some word from federal court or from another court that it's been placed in some type of receivership, or this matter is kind of ongoing. Some steps have been made to come into compliance, and Mr. Pell, you've assured me that those steps are taken. I want confirmation of that from Mr. Staples. the fine has been paid as I've looked at. I do think there's an outstanding $14,250 balance that is maybe one of the previous fines, and I'm going to look at that. But I would think that there is a federal district receivership case this week. Is that correct?
Correct, on Thursday.
All right. So I don't know where this case is going, and nor do the attorneys. I think that this would be, Mr. Pellis, I read your brief. This would be civil contempt. It would not be criminal contempt. This is a quasi type of contempt, would be a quasi contempt, because there's no, unless I find that there's no criminal sanction that goes along with being a non-compliant except civil, and then the look at trying to get you to comply. That's my understanding of civil contempt. And so that would fall along these lines, that we're looking for compliance, which may or may not be an issue, but it seems to me that an additional 30 days to keep track of this so it doesn't fall through the cracks, to understand what's going on in the other courts, and to see what measures of compliance you've actually done in regards to security, in regards to anything being pulled, in regards to any type of things being measured. I will hold off on any fines or lien sanctions at this point in time. Because I want to figure out what happened, because there's 14,250 that's missing somewhere, and we got to find that, because I want the computer to be right. But B, because this case may take a turn in a different direction that's far beyond the level of Mr. Staples in the city, especially if there's a request for receivership or anything else along those lines. I don't know, but it seems like a 30-day cooling off period will allow Mr. Pell to come in to seek whatever modifications in compliance, at least start those things going, and then to see where the case leads us. I think that's the fairest thing to do with Mr. Pell coming in. And of course, you've had absolutely very little time to respond, or a brief time to respond to the motion. But it seems like fairly straightforward. This would be seeking civil compliance. We've looked for fines in the measure of compliance. It appears that everything's been paid, and then there's a $14,250 balance that we're trying to figure out where that came from. That could come from other fines that made its way over. I just want to make sure of that and confirm that. So we'll seek a date 30 days out to come back. That'll tell us where the other cases are, and then that'll lend us to see if this is in compliance for that measure. That'll also give you time to digest anything you need to do on the new motion, and allow myself and my staff members to work through these orders to make sure that there's no outstanding balances. All right. Yeah. So let's do that for right now. So right now, I'll place any show cause requests for show cause and abeyance. We'll deal with that. Or I can actually put that aside, because payment has been met to the city's confirmation of $43,500. The one thing, and then the $14,250 was previously paid. And then we want to find out the nature, if there is a $14,250 balance. I'm going to put a big question mark, because I think that was a previous fine that came from someplace before, and then it's well within my discretion. Okay, if I've already set the fine, if it has just been folded into something that's already been done, and then we can dismiss it. All right, go ahead, Mr. Pell.
Your Honor, I think, and please correct me if I'm wrong, I think that what both the parties are understanding is that $14,250 fine that you have written down that was paid is the same as the $14,250 that you're putting the question mark down to, but just those funds went directly to the city as opposed to the court.
That's my thought process. Correct. But I wanted to go through. But if both sides are stipulating that there is no $14,250 balance, then I will disregard it today if both sides are stipulating. Mr. Staples.
Your Honor, I think for just clarity and safety's sake, I would appreciate if the court would do a review and make sure that it hasn't slipped through the cracks. That's my understanding as well, but given the amount of orders in this case and the things back and forth. I think for
I'm
safety's
more than
sake-
willing. Yeah, I'm more than willing to do that. If I come up with a different number, I'll let each party know before the next hearing.
Okay, Your Honor. And then just on that same point then, I think if you look in the court system, what I saw and what the court, Ms. Holden, I believe, saw was that there was actually a $58,000 balance. As Mr. Staples was saying earlier, both the parties were under the understanding that it was just a $43,500 balance.
Right.
So that is partially the $14,250 that's outstanding that was actually already paid, and partially that separate $10,000 and $5,000 fines that were held in abeyance or disregarded in place of the ultimate $33,500.
Correct.
So I just want to make sure that that's what previous counsel advised. That's I was talking to Mr. Staples before. That was his understanding, and so I think that's correct. But obviously, if there's something different, I'm
right. I think all of the fines and costs were lumped in together, and so we're going to pull them apart and see. That's my understanding. My understanding it has been paid off, but I'm going to go in there and look at it just to make sure, and then we'll get a new date 30 days out for the parties to come back in. We'll address what compliance measures have been done, the status of the case, because this case it's now growing into multiple parts. And then, but one thing that we're still here on is making sure that the city and code compliance are all measured with in the next 30 days. And then I'll seek more discussion from Mr. Staples concerning what should be done on that level. But it's really the third part of a three-part case now. I mean, there's an Eaton County case and a federal case out. So I understand that, but we still want to keep mindful of that this case is ongoing. All right.
Correct.
So we'll look into the outstanding $14,250 balance. Let me look into that, and then we will set this 30 days out for review on the compliance. So review on compliance, and that'll be set for
October 1st at 1:30.
October 1st at 1:30. And then if I have a different number or different accounting, I'll let each party know, and then we can set it for that date also. Okay, for any discussion and any type of how we got that number will be both given to both parties. All right. All right, so the total number to be in review, and I will see everybody on October 1st at 1:30.
Ready.
Thank you.
Thank you very much, Your Honor. Nice to meet you.
Nice to meet you too. And then Mr. Kirksey. You got me worried about whether I had the right date or not.
I don't know.
All right. So we're on the record in docket number 2400616. That's people of the state of Michigan versus Marcos O'Neill Kirksey. Will the parties please introduce themselves for the record? Mr. Gehring.
Joel Gehring on behalf of the city.
And sir, you are Marcus O'Neill Kirksey, is that correct?
Yes, Your Honor.
And you are not represented by counsel today, is that correct?
Correct, Your Honor.
And so I've had the opportunity to take a look at the file. And this stems from a Killebrew agreement of no jail time. It was referred to probation. You pled to count 2, which is the operating while impaired, and you were without counsel when you pled. Is that correct?
Correct.
All right. Have you had the opportunity to go through the pre-sentence report, Mr. Kirksey?
Yes, I have.
All right, Mr. Gehring, is there any restitution on this matter?
There's not, Your Honor.
All right. There is, I do have an LPD cost of $271.70. Is that a correct assessment, Mr. Gehring?
And my understanding is that is correct.
Okay. All right. So in the pre-sentence report, Mr. Kirksey, do you see anything that needed additions, deletions, or corrections from the report itself?
No, it looks pretty accurate to me.
All right. All right. Allocution, Mr. Kirksey, anything you'd like to say to the court concerning the judgment of sentence now that you've looked at the pre-sentence report and what they're recommending?
No, Your Honor, I'm accepting full responsibility, and I think it was pretty accurate as far as everything that they said in the statement.
All right. As I looked at it, I thought it was a pretty fair statement myself. Mr. Gearing, do you have any comment concerning this matter or the sentencing of this matter?
We leave everything to you, Your Honor.
All right, thank you. So Mr. Kirksey, you understand, you were very candid with the pre-sentence investigator. As a matter of fact, you've been fairly candid throughout this process, all right? And so, which goes a long way with the sentence, because it's easier to work with somebody who's indicating this happened and I want to make it better. I want to do better. And by the way, I look at district court as a way to help people. Okay, we're not. It's very rare that we really punish anyone in district court, and most of the time that comes to us with under the guise of they have such an incredible history that we want to protect the community, and so we put them away. I don't see you in that light. You don't present in that light. Your pre-sentence doesn't present in that light. So I'm gonna put this as a learning experience. All right, this is an absolute learning experience, and so I'm gonna adopt the recommendation of judgment of sentence. The only thing that they're really looking for is a 6-month probation, and anything to be directed by probation. And really, that is to see if you're going to have a productive relationship with alcohol or a destructive relationship with alcohol. This, as you know, can be kind of destructive. All right, and so, but you don't present as somebody who is in need of constant attention. All right, but if you start failing and dropping dirty, I see that maybe we've got a problem. Okay, and then it's up for us to help you with that problem. Okay. I'm not concerned about Mr. Kirksey in the next 6 months. I'm concerned about Mr. Kirksey in the next 6 years, when you've got to make decisions based on independent evaluation of your life and whether you're going to make good decisions or bad decisions. All right. I'm going to chalk this up to a learning experience, and that's why I'm going to accept the recommendation. So this is for the guilty plea for July 2nd, operating while impaired. I'm going to minimally set fines and costs in this matter, and then we'll accept the Killebrew agreement of no jail time. So the fines and costs, I'm going to set fines at $250, costs at $250. Crime victims' rights fee is $75. State minimum cost fee of $50, and then probation at $30 a month for $180. So that does add up a little bit, but that can be paid over the course of the 6 months probation. I'll give you a total number for that. So that's $805, and then the LPD recovery cost is tacked onto that for a total of, well, that's not right. It's 500. Is $1,076.70. You're to be put on probation for 6 months at $30 a month. You're to spend 93 days in jail beginning August 27, 2024. Credits giving for 2 days previously served, and I'm suspending the 91 days. All right, that's the following the Killebrew agreement, and that and all of this is really the stick. All right, if you finish probation, you do what you need to do. There'll be no more jail time in this. Okay. If we keep seeing each other and you're dropping dirty and I'm seeing you all the time, then I've got 91 days to play with. And really, that's just keeping the community safe. All right.
Understood.
Okay. So probation is set for 6 months. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PVTs and/or urinalysis as directed. No bars or nightclubs. The other here is, at the direction of probation, you may have to attend some rehabilitative services I think they're keeping that just in case, but make sure you know who your probation officer is, and that should be directed by probation. The main thing here is that I see is a 10 victim impact panel with 90 days with verification. In the next 90 days, get that impact panel done. That might not only be good for you, but it also could be good for anybody who's attending, who is part of the panel, who gets to see your story, because everybody's got a story. And I think it's important for you to share that story with others so that they have an understanding that this really could happen to anybody. Okay, it really could happen to anybody. Anybody can drink too much, get in a car, and think they're all right, and the law doesn't care. The law just puts you at a certain level. Okay. This will be a reportable conviction to the Secretary of State. It also says obtain and maintain employment, which you're obviously doing. Do you have any questions of me concerning the judgment of sentence, Mr. Kirksey?
No, Your Honor, but actually I do have one.
Okay.
Regarding the Secretary of State, my license was revoked for a year. I didn't know if I needed to go through you to.
Probably have to go through the Secretary of State.
Yeah, they said something about circuit court, I believe.
Yeah, you're gonna have to go and you're gonna find out all, and this is not to be taken lightly. So prioritize that. Go to the Secretary of State and find out exactly what you have to do to get your full license back, because they're gonna have their own rules, their administrative rules. I'm telling you, it's going to be reported to you. The OWI is going to report it, but then they're going to have their own system, and you might have to go to circuit court. All right, you might have to go and petition circuit court in order to get the license back. And some, since this is, and they have their own rules, so you'll have to follow those rules. Any other question? That's a good question.
No, I think you
all right.
covered it all, Your Honor.
All right, so I'm going to. Oh, I did. All right. So, and the boxes check is over the course of probation for the 6 months, not purchase or possess firearms, ammunition, or weapons of any kind. Everybody who goes on probation gets that order from me. So not purchase or possess firearms, ammunition, or weapons of any kind. I'll sign the judgment of sentence. That's 8/27/2024. So you should go down, Mr. Kirksey, and find out who your probation officer is. I have Mr. Hanna, who's easy to work with. He's fairly flexible. Okay. You want to meet with him. Just make sure that you're on the page, that's the person you got to meet with, and then you should be all set from there. All right.
Sounds good.
All right. Anything towards the sentencing of Mr. Gehring?
Nothing from the city, Your Honor.
All right, Mr. Kirksey, it is the way this works best if we see less of each other. All right. And you must have better things to do with your time on a Tuesday afternoon on the hottest day of the year. Okay. So go see Mr. Hanna and good luck to you, sir. Okay. Thank you. Thank you, Mr. Gehring. Mr. Candy's here.
30% Washington, and Mr. Spock is here.
And what's his name? I'm for the attorney for Mr. Brown.
Ron Bach.
Let's see, Mr. Buck here. And Mr. Sheets attorney, Mr. Niels here. Let me pull those up. And Mr. Neal, you're here for David Sheets in that hearing?
Yeah.
All right. All right. Mr. Neal, you're breaking up a little bit, so I'm going to stand by, but your technology is breaking up a little bit, so I can't hear you. So I'm going to pull all these files up, and then we'll start calling them.
actually leave for back.
Mr. O'Neill, can you hear us now?
I can hear you, Judge. I apologize. I'm in
Oh.
a bad area here in Shiawassee.
Right. That's all right. Would you like to meet with Mr. Candy in a breakout room?
Sure.
All right. We're setting up it on iPad, and we're going to go ahead and put you both in a room. So you should get a prompt to go to room 1.
Okay, will do. Thank you.
Thank you. And then I'll assign the iPad to room 1.
All right, let's see. Okay,
There we go.
My worst thing is I'm like concentrating on something. You're looking at me like, what was I supposed to do?
Right. I went ahead and put them in room 1, James.
Yep, thank you, Judge.
And then we're rating the Mr. Buck. Mr. Buck, I lose you behind there. We're waiting on Tayon Jackson and Gary Parks. Well, there's no reason to wait anymore because we're past the 15-minute allowance.
Jack?
So that's Miss Toltzman, and then you have Mr. Parks. All right, so Miss Toltzman, you can come up here. We'll go in order. That's South Washington. All right, so we're on the record in docket 24-03-114. That is South Washington Park versus Tayon Jackson. Will the parties please introduce themselves for the record, Ms. Toltzman?
Alex Tolzman appearing on behalf of Plato.
All right. And this is the time set for a landlord tenant hearing. It was scheduled for 2 o'clock. It is now 2:20. Gonna do the dangerous thing and pull this up. This was set on July 17th that all parties met in a breakout room and the tenant was to meet with legal services. We set this for formal hearing. That was a live hearing with evidence to be brought if we did not receive an appearance from legal services. And we have not received any appearance from legal services. Ms. Holtzman, have you received an appearance or anything from legal services?
No communication.
No communication. All right, thank you. All right, so this was set for 2 o'clock. It is now 2:21. It would appear the defendant has failed to appear for the landlord-tenant hearing. I do not see a Tayon Jackson in the Zoom courtroom. There's nobody by that, the physical room. And did you see anybody meeting that description? You had the opportunity to meet with them?
I went in the hallway and checked and I didn't see anyone.
All right. And no one was that way in the hallway. Ms. Toltzman, how did you want to proceed?
We move for a default judgment at this time. Rent to retain possession is $2,973. Court costs of $177.04 for a total outstanding balance of $3,150.04. I believe we're working with a writ date and an appeal date of 9/6/2024.
That's right. To the best of your knowledge, Tayon Jackson is not a minor, incapacitated, or in the military service. Is that correct, Ms. Holtzman?
Yes, not to my knowledge.
And to the best of your knowledge, the premises was kept for its intended purpose.
Yes, to my knowledge.
All right, I will sign a order, and you'll follow that up with an order, and I'll sign the default.
I have it here today.
Okay.
You want it now?
Yes.
Okay.
Thank you, Ms. Toltzman.
Thank you.
All right, I'm in possession of a default judgment in regards to the terms placed on the record. Boxes 1 and 2 in check. The total amount is $3,150. 4A is checked with the plaintiff can apply for an order evicting the defendant. If the defendant is not paid, the plaintiff or the court the amount in 2D above or does not move out or before September 6, 2024. 5, 6, and 7 boxes are checked. Partial payment will not be accepted, and the September 6th date matches the appeal date. I will sign this document. To that effect, and then Ms. Toltzman, you can receive we'll sign and scan it, and then you can receive a copy for your file. All right, ma'am?
Thank you.
Thank you. You're all set.
Thank you. Have a nice day.
You too.
Of course they can. You're actually programmed in there. You should be. I think we did them all. Okay.
Yeah, I know. It happens.
What's in a blue moon? I had to add Megan and I just was on a roll.
Yeah. All right, Mr. Bach, let's call your case. That's 3129. All right, so we're on the record in docket 2403129. That's Skyline Apartments versus Gary Parks. Will the parties please introduce themselves for the record? Mr. Bach.
Yes, good afternoon, Your Honor. Ronald Bach here for the plaintiff, Skyline Apartments.
All right, and this was scheduled for 2 o'clock. It is now 2:25. Is there anybody by the name of Gary Parks? Gary Parks in the courtroom? and indicate we previously met on July 17th, 2024. All parties appeared. The tenant was going to meet with legal services. We did not receive an appearance in legal services. Mr. Bach, did you receive any appearance or had any discussion with Mr. Parks?
No, Your Honor.
All right. So this was set for 2 o'clock. It's now 2:25. Is still to appear for the landlord tenant hearing. And Mr. Bach, how did you want to proceed today?
At this point, I request a default judgment to enter.
Are there any terms you wanted to place on the record?
Yes, at this point, according to the ledger, there's some recent payments, which is a little bit out of the ordinary, being that we're here now. But maybe he plans to get this paid off. $1,945 in rent to retain with $179.08 in costs, but to a total of $2,124.08 to retain possession. I put down 9/6 as the pay date and 9/6 as the appeal date.
And do you have an order to that effect?
Yes, may I approach?
You may. Thank you, Mr. Bach. All right, so I'm in possession of a default judgment in the case of, I think you have, this should be Skyline Apartments, right?
Yes, sir.
Yes.
Yeah, I think we got Mr. Brown's. So
Yeah, Mr. Brown today.
you are Mr. Brown, but that shouldn't be part of the plaintiff attorney, should it?
No.
Oh, you're Mr. Brown today. I get it. The plaintiff is Skyline Apartments. I got it. All right. I misread the plaintiff portion of that. All right. So box 1 and 2 is checked. Box 2D is for the amount placed on the record, $2,124.08. 4A is checked with the writ date of September 6, 2024. 5, 6, and 7 checked. Partial payment will not be accepted. September 6 is the appeal date that matches the writ date, and I will sign accordingly. All right, and we will sign and scan it. Make sure you have a copy for your records. All right, sir?
Thank you, Judge.
All right, thank you, Mr. Bach. That's all for the record on 2403129.
Thank you.
No, next one.
Then Mr. Candy, you can come up here. Right, so we're on the record in docket 2403094. That is David Sheets versus Xavier Candy. Appearances for the record, Mr. O'Neill.
Good afternoon, Your Honor. Rico Neal appearing on behalf of Mr. David Sheets.
Thank you. And sir, your name is Xavier Candy, is that correct?
Kennedy.
Kennedy.
Yes.
Let me correct that because we have it as Candy. I want to make sure and place that in the notes. So that was amended to read Canady, Canady, is that correct?
Sure.
Not. So, sir, you are Xavier Canady, is that correct? Thank you. This is the time set for a landlord-tenant hearing. Mr. Neal, how are we proceeding?
Thank you, Your Honor. I've had an opportunity to discuss this with Mr. Kennedy. At this time, we will enter into a consent agreement, consent judgment, Your Honor. The consent judgment terms are is that Mr. Kennedy will pay $4,297 in back rent plus $82.75 in court costs for a total cost of $4,379.75 on or before September the 6th. If not, he will vacate the property on or before September the 6th.
And Mr. Kennedy, is there anything that Mr. Neal said on the record that was not part of your agreement? All right. And Mr. Neal, you'll advance an order to that effect. Did you need
Yes.
authorization for Mr. Kennedy to sign that on his behalf?
May we, Your Honor?
Yes. Mr. Kennedy, do you authorize Mr. Neal to sign the document to advance to the court as far as the consent judgment on your behalf? Authorization's been granted, Mr. Neal, so you can sign it on his behalf. Mr. Kennedy, you understand that the court rules indicate that you have 3 days from today's date to somehow say that what we did here was vague or ambiguous because you don't have counsel. Do you understand that, sir?
Yes, I do.
Seems pretty straightforward. It's a pay or vacate type of arrangement that you've agreed to, but I've explained the court rule to you. Is that correct? All right. So the orders to follow, is that correct, Mr. Neal?
That's correct, Your Honor.
All right. So you will get a copy of the order sent to you from the court to your last updated address. All right, sir? Anything else for the record in docket 2403094, Mr. Neal?
Nothing further, Your Honor. Thank you very much.
Thank you. Thank you for your appearance today, Mr. Kennedy. You're all set.
Thank you, Your Honor. Have a good day.
You too.
He's ready to vote the security Aaron Cox
Okay.
files.
Perfect.
Both are consent judgment.
Mr. Scotty, how are you?
I'm good, Your Honor. How are you?
Pretty good. And you're ready on Riverfront and Capitol Commons?
Yes, Your Honor. I have two consent judgments.
All right, let's do the 3134. That would be Riverfront. All right, so we're on the record in docket 24-03134. That's Riverfront Apartments versus Alan O'Neill. Will the parties please indicate their presence for the record? Mr. Visconti.
Good afternoon, Your Honor. Robert Visconti, P61756 for the plaintiff.
And sir, you are Alan O'Neill, is that correct?
Yes.
Thank you. This is the time set for a landlord-tenant hearing. We previously met on, I don't have any jacket on this. We must have met before because
We did, Your Honor. It looks like the notice was
The
issued
17th.
on July 17th.
okay. All right, Mr. Visconti, how are we proceeding today?
Your Honor, we have a proposed consent judgment for the court's consideration. The judgment's for possession only. It reflects a rental arrearage through the month of August of $4,816. Court costs of $193.54 for a total redemptive amount of $5,009.54. With an order of eviction to issue if that amount's not paid in full by September 6th, 2024. Mr. O'Neill has requested that he be given a copy of the judgment today to take to the agencies he's working with. I do have an order prepared, signed by both parties, and I did advise Mr. O'Neill of his right to rescind pursuant to MCR 4.201J.
Perfect. Do you have an order ready?
I do. You may
All right,
approach.
you may approach, Mr. Visconti. And sir, as I'll reiterate the court rule, you have 3 days from today's date to somehow say that what we did here was vague or ambiguous to you. You didn't understand it. I'll go through the order with you again, but you understand that court rule, sir?
Yes.
All right. This is a consent judgment signed by both parties. I will indicate that the rent to retain position as indicated is $4,816 with court costs of $193.54 for a total of $5,009.54. 4A is checked as September 6th being the date. The writ date, the appellate date matches. 5, 6, and 7 are all checked, and partial payment will not be accepted. I will sign the document accordingly. I'll also put the court determines a valid waiver of rights exist in the terms of consent judgment are fair. I will sign this to today's date. for August 27th, 2024. And Mr. Visconti, you should get a copy. We'll make a copy of each for your court file and for Mr. O'Neill to add to his paperwork. All right.
Thank you, Your Honor.
All right. Anything else for the record in 2403134, Mr. Visconti?
Nothing further.
Mr. O'Neill, do you have any questions of me?
I have a question. What about the lease? Is there supposed to be a lease?
If we'd gone to a hearing, there would have been a lease, yes.
Yeah, there is no.
Okay, so you're on a month to month then.
Yeah.
Yeah, once the lease runs out, you're on a month to month.
Okay.
You don't have a lease, you just go month
Yeah, I
to
was
month.
just wondering
All
about
right.
that, because she
Okay.
had a lease in there, but it's not.
Right. If there was a lease at one time, we take a look at it at hearing, but you go month to month after that lease expires.
Okay, because I can only get like 2,700 at this time, and they won't even take a payment.
All right.
So.
Well, partial payment will not be accepted, but do the best you can concerning this matter. The September 6th date seems like the main date.
September 6th is the main date, and Mr. O'Neill had indicated that there are additional resources that he's going to try to access as far as perhaps other funding resources, agencies that might be willing to assist.
All right. All right. Well, keep your property manager abreast of anything that you're able to get with the order, and you should be all set. Thank you for your appearance today.
You get a copy.
Yeah, I can get a copy.
Thanks.
Yep, thank you.
What's that? I didn't have the last when the pretrial was on this. I have a hearing jacket. I just didn't have I didn't have a complete hearing jacket.
You probably do that.
Well, that's.
Pick whichever one you want to use later.
All right. Let's. Capital Commons. I don't see. One, 3, 3, 1,
7, 8.
7, 8.
Second word in the half. At least what I'm looking at.
Yeah. Nine, 7. I was seeing, I got Judge Milmore's, Magistrate Milmore's for a second. But I'm all good now.
You're all good?
Yeah, I'm all good.
I need to delete this extra.
So
O'Neill out of here.
2403978, that is Capital Commons Limited Dividend versus Amy Hanushak.
Hanasak, sir.
Hanasak?
Your Honor.
All right, ma'am. You can come forward. Appearances for the record, Mr. Visconti.
Robert Visconti, P61756 for the plaintiff.
And ma'am, you are Amy Hanasak?
Yes, sir, Your Honor.
Thank you. This is the time set for a formal landlord-tenant hearing. We previously met on July 17, 2024. All parties appeared, and we are now at the formal hearing stage. Mr. Visconti, how are we proceeding today?
Your Honor, we have a proposed consent judgment for the court's consideration. The judgment reflects a rental arrearage through the month of August of $640, court cost of $193.54 for a total redemptive amount of $833.54. An order of eviction to issue if that amount's not paid in full by September 6th. I do have an order prepared that's signed by both parties. I did advise Ms. Hanasek of her rights pursuant to MCR 4.201J. And if I can present the order.
Absolutely. And that's the September 6th writ date. Is that correct?
Correct.
Okay, thank you. I'm in possession of the consent judgment for 2403978. Is this the consent judgment with box 1 and 2 checked with the amounts that have been placed on the record, with the total amount being $833.54. 4A is checked. The plaintiff can apply for an order evicting the defendant if the defendant does not pay the plaintiff or the court the amount due in item 2D above or does not move out before September 6th. So September 6th being the big date. The appellate date is the same date. 5, 6, 7s are checked and partial payment will not be accepted. The court rule was explained to, and I'll reiterate that the Michigan court rule indicates you are not represented by counsel today, so that you have 3 days from today's date to file a motion to say that something we did here was ambiguous or you didn't understand it. All right, ma'am?
Yes, sir.
You've signed the bottom of this document, is that correct?
Yes, Your Honor.
All right, thank you. All right, I will sign the document.
I just have one question. You said get an order of writ on September 6th.
Six, if you don't
It has
pay.
to be after
After
September.
September
After
6th. So
September
the first day we could
7th.
ask the court for an order of eviction would be the 7th. And that's if you are still there and you have not paid.
Okay.
Perfect. I couldn't have said it better myself. It's
Thank you.
September 7th would be the order of eviction. That would be the first day they can come to me. And that would be if you're still there and you have not paid the amount pursuant to
sir.
the agreement. All right.
Yes, sir.
All right. Do you have any other questions of Ms. Anderson?
No, Your Honor. I don't.
All right. Any questions of me, Mr. Visconti?
No, Your Honor. Thank you so
All
much.
right, thank you.
Have a blessed day.
I will sign and scan it. And you probably should take a copy for your papers, okay?
Okay, yes, sir.
All right.
Have a blessed day and happy holiday.
All right, thank you.
Somebody left their phone in the courtroom, sir.
Yeah, the court officer saw that.
I noticed that
Yeah,
when I walked in as well.
that'll go right to whatever lost and found we have available.
I believe they're actually coming back, Judge. I think
Are they?
I have to speak with Mr. Bach, if it's who I think.
All right. Well, Mr. Bach spends plenty of time in the courtroom, so we know how to find him.
Thank you.
Thank you.
Have a nice holiday.
You too.
What's your name, Mr. Whitty? Pleasure to see you.
Yes. Not a problem. Mr. Whitty, how are you?
I am good. I should probably go sit in the hall in case my next victim shows up.
You have Diane Black and Carrie Beard.
Yep.
All right.
Either one.
All right.
Two trials in there or one?
I have two.
Uh-oh.
I have REO Gateway versus Diane Black, and I have LG Park Place versus Carrie Beard.
I better find out what's going on with that.
All right. I have
Came
two.
in here and sat here a minute.
Now I put you to work.
What?
In case never help you.
No. We don't organize like that.
Gotcha.
Oh. South Washington is. That's the one we did on the very first, right? With Miss Toltzman.
Yes.
Is Mr. Bach here for Mr. Brown on the second one? 3132.
Yeah, he's here for all of this. Mr. Brown.
All right, and he was here on 3132. Is that the double? Let's see. If not, we'll just act like,
I took care of the double one.
okay, because there's one that you might have taken care of the one that, well,
The one that was held, I left alone.
that was a default judgment.
Ready on.
We're ready.
All righty.
It's on the record.
Consent. Conditional dismissal. How we proceed?
Conditional dismissal, sir.
Wonderful, Mr. Bach. Thank you.
This is REO Vincent. And Rachel Sykes. All right, Mr. Box, we can call your next case. Ms. Sykes.
Nope, that's Miss Huxtable.
Ms. Huxtable.
Sykes is set for 3 o'clock.
All right, so you're gonna have to make me one on Huxtable. Because I think I closed that one for some reason. That's on me. I'll worry about that later. 2403132. And I think I just closed it. It's the first one at 2:30. All right, we can go for it on that one. Ms. Huxley, you can come up here. All right, so we're on the record in docket 2403-132. That's REO Vincent Apartments versus Aviana Huxtable. Will the parties please introduce themselves for the record? Mr. Bach.
Yes, good afternoon, Your Honor. Ron Bach here for plaintiff REO Vincent Apartments.
And ma'am, you are Aviana Huxtable, is that correct?
Yes.
All right, thank you. This is the time set for a landlord-tenant hearing. Mr. Bach, how are we proceeding today?
We are proceeding with entry of a consent order for conditional dismissal. The only term is there's no money involved. Defendant has agreed to vacate on or before September 30th, 2024.
So September 30th being the date of the one condition.
The one condition.
Okay, thank you. And Miss Huxtable, did Mr. Bach, did he indicate exactly what the agreement is that you agreed to? Was there anything that he said that was not in your agreement? All right, Mr. Bach, do you have an order?
Yes, ma'am, Coach.
You may. Okay, all right. So I'm in possession of a consent order for conditional dismissal in docket 2403-132. This includes, this is REO Vincent Apartments versus Aviana Huxtable and all occupants. The only condition that is in place is defendant shall vacate the property on or before September 30th, 2024. Box B is checked as the action may proceed without notice to the defendant for further process. The court rule is explained to, and I will reiterate the court rule that you have 3 days from today's date because you are not represented by counsel to indicate that this was somehow vague or you didn't understand what happened today. Do you understand that, ma'am?
Yes.
All right, you signed the bottom of this, is that correct?
Yes.
All right, I will sign the conditional dismissal. I will sign it to that effect, and then you can both receive a copy once it's scanned and signed for your records, all right?
Thank you.
Anything else for the record in 2403-132, Mr. Bach?
No, Your Honor, thank you.
Ms. Huxtable, do you have any questions of me?
No.
You're all set. Thank you for your appearance today.
Thank you.
Now. It's 3133.
3132.
3132. I don't have. Let me.
Thanks, sir.
We got one more for you. Bob.
Yeah, I got one more set.
All right.
Thank you. Thank you.
Good luck.
You take it. Second from the top.
There it is.
Gosh, the bullet, Judge.
Did you? How did you do that, Mr. Bach?
It's either we agree to let her go with no rent paid, or we're gonna spend the next 3 hours looking at pictures and text messages. Except my witness just had a baby prematurely, so I would have just asked you to kick it out.
All right. Well, you did dodge a bullet then. And I
For you,
appreciate
I
it.
dodged it for you.
Yeah.
I'm here till 5. It doesn't really matter what I'm doing.
We were here till 7 last night.
I just said, hey, you know what? The judge is gonna split the baby. He's gonna give you a discount, but he's not gonna give you 6 free months.
That's
what
true.
I'm offering.
Yeah.
Come back now.
I just want to ask Wendy a question.
Wendy.
Ms. Lopez failed to appear this morning. She's in your 48-hour hold. She's set for pretrial with you guys on the 3rd of September. Can I just add these to that?
Sure.
Yes.
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 Well, that's what I figured. Yeah.
That seems very efficient.
Yeah.
Yes. Thank you.
Yeah,
I
no
like
problem.
efficiency.
It's such a surprise, but I'll be with you tomorrow.
Shocking.
We don't have a regular landlord tenant anymore.
Civil jury.
Fine, that better not be running.
Surprise.
Is anything going?
We have a civil bench.
Okay. Which one's that?
I knew you were gonna ask that. I'm getting there.
I have absolutely no desire to run a civil hearing tomorrow, so Wendy, I'm gonna need you to take that up for me.
There is not one on the docket, so wish granted.
Huzzah.
The civil bench is anesthesia and pain management versus Rhonda Wade.
Can you also make that go smoother or quicker?
Sure. I don't want to do
Who's the
that.
attorney on that?
Well, it's an attorney from out of Pittsburgh, Pennsylvania that's not admitted to practice in Michigan, so I don't know who they're sending.
Oh. All right. Well, let's wait and see how that one goes.
Yeah, you know
should
my view on
They
civil
should all
day.
work that out.
Yeah, okay.
Somehow, Wendy, I think you and Shelley have a pretty similar opinion on civil.
Yeah.
Oh, we have another civil bench. I missed this one. This is community mental health. Oh, Lord. This is
CMH.
a patient suing CMH.
Well, that's gonna be fun.
When does that?
That is at 9:30, so I would suggest we get some extra caffeine. I can't do this.
I don't
right
remember
now.
that. I don't remember that.
I don't remember this at all.
Oh,
I'm looking. Who the heck
you
is
got to
the
build a
pre-trial?
jacket for them. So I don't remember pre-trial on that or.
I believe civil builds the jackets for that kind of stuff.
Yeah.
They just don't, the only
This
thing
is
they don't
appealed-
build it
This
for
was
is.
appealed out of small claims,
Oh, those are my favorites.
so nobody ever.
I mean, yeah, but what about our progesterone karaoke machine, progesterone machine and karaoke machine out of small claims case that we got? Where we almost had to send a grown woman to jail because she and this other grown woman couldn't stop bickering and work out the turning over of a karaoke
That
machine.
sounds like a karaoke. That sounds like a small claims case. Small claims cases are not about the actual thing. It's something well beyond that.
There was also a machine, I understand, that was a progesterone machine for dogs, but that was resolved before it got to us.
I wonder if it's Winston's past owners.
Who knows? That it wouldn't surprise me. That's the most expensive dog of all time.
I never know if she's yelling at somebody if they're messing around over there.
So Riverfront versus O'Neill did that.
But now I'm super curious about this case.
Well, you'll have your curiosity be sated tomorrow.
No, I need to know if I need to prepare myself mentally, like.
You're right. You mean you're not like Shelley, just mentally preparing yourself for any amount of landlord, tenant, or civil at all?
Well, sometimes I say things under my breath that I probably shouldn't, and apparently I say them louder than I realize.
Yeah, you sound loud enough to be on the record.
But it's funny because I can't hear them through my headset.
Everybody else can.
I know, it's just.
So
weird.
you need to avoid that.
That's what I'm working on.
That's a good.
That is the thing.
I'm just lucky nobody can see your eyes.
Oh, if they
that
can
was-
ever see my face, we're in trouble. The
Yeah.
new courtroom is perfect because you can't see me.
Actually, I'm not in trouble.
In this case,
No,
Shelley-
I'm in trouble.
Yes. You're gonna have to develop a poker face.
Yeah. I think it might be too late for that, Judge.
All right, so Mr. Box on to Rachel Sykes.
Yes, I believe he's waiting for her to appear,
All right.
and Mr. Whitty's waiting for his 2 points to appear.
All right. So the 9:30 is the mental health patient is suing. What are they suing for?
I'm working on it.
Those have a tendency to go a little longer. Because
So magistrate found that the defendant,
Just community mental health.
yeah. This doesn't make any sense. It says the defendant must pay the judgment to community mental health.
And is it that he's
To pay it
appealing that
yourself.
judgment?
Who's the defendant?
The defendant is community mental health. This order doesn't make any sense to me. I'm printing this.
That's a fun start to tomorrow.
Yeah,
It sounds like, there's an error. If who's appealing the defendant, maybe they're appealing the amount. It's a novel review.
I think that there's an error, but I don't know. Or maybe I'm just not getting it because my
Okay,
brain
this
hurts.
is for Lynetta Curtis against community mental health. Resort, the judgment is granted, and the defendant must pay the judgment to.
Thank you, please.
Diane Black.
It's Mr.
All right,
Wiggins.
yep, I see the attorney on your case is here. I'll let him know you're here, all right?
They just told me today that, I just found out today I didn't qualify for an attorney, so now I
Oh,
don't
no,
have.
The opposing
The
attorney.
attorney for the
Oh,
landlord.
okay.
And you can talk to him, all right? So he'll probably want to talk to you.
Okay,
Without.
all right. They said they sent me notice, but then they read the email back to me and it was the wrong email.
So apparently this case doesn't have, the plaintiff filed a case against CMH because they refused to pay her for hours worked.
That was granted.
That was just the small claims claim. That was granted. I don't know what that means. It kind of contradicts it.
Yeah.
We can ask Magistrate Milmore, or no, we cannot. Magistrate Milmore is not available. She's on vacation, I believe. Magistrate Milmore has been separated.
And the judgment's not even set. This is judgment 4.
Check our rates.
It says the defendant must pay. So community mental health must pay community mental health in full. It doesn't make any sense to me. This is a paycheck case.
Regarding 3 p.m., Mr. Liddy does only has one file because his other one is dismissal.
All right.
Yeah, yours a dismissal and Black he's talking with.
Oh, thank you. So if you were just dismissed.
All
Okay.
right.
Thanks, Judy.
And he's
Yeah.
gonna submit it. Look. That one I don't,
Okay, so
something's
I'm
wrong
not
with that
losing-
order.
I'm not losing my mind.
Well,
At least
that's not a mental health patient. That's a paycheck. You're looking at this, but that order is that community mental health, pay community mental health. I think, is she still an employee of community mental health?
It doesn't say. The
Well,
connected documents are not helping me a whole lot.
you might have to work that out tomorrow. Like having hearing,
Oh, that's what you meant. I was like, I don't know if they put anything in the
like
record.
taking testimony and everybody tells us their side of the story.
I wonder if she puts her small claims on the record.
She doesn't, but we do.
I know, but if,
This is an appeal.
because when she does her arraignments, she has DCR, she records herself. Like, there's
Oh,
no.
I have no idea what she
Oh.
does, but I know that
didn't-
we do.
That might give me some clarity. If she
Yeah.
did record this, I can go back and listen to it.
somebody appealed, so it's a de novo review and. But we don't get a lot of help from,
That doesn't. And
those small claims are the worst because they never have anything to do with it's always a personal thing. Help, and you know, help you if it's a property dispute. So it has nothing to do with the property.
oh,
Has to do with two
that,
neighbors
that
fighting.
was something.
That just has to do with people not getting along with other people. That beats 40 pre-trials though.
That's true. It does. You have.
I'm gonna remind you that as we're hearing the testimony that you did, this is your happy dance for the 40 pre-trials.
She did not put small claims on the record. She only put the actual jail rate.
That's
Interesting.
it's
Now I
not
know.
claim, it's not usually placed on the
No,
record.
I was just curious.
And then I think they have a certain time period to appeal. And then we get it and we either,
Wonder why.
well, you never wonder why. You may not agree with her decision, but you never wonder why. So so get the waiver form ready. Each party's got to sign that.
Just in case I'm
And we'll
kidnapped,
scan
this
it.
is where I keep them.
Oh.
And, you know, type. I need a waiver.
Usually what we say is it's over there in windy stuff, so.
He
And
was
then
just-
everybody's going through the files looking for it. That's happened like when we have like prelims we've already taken testimony on.
Yeah.
Yeah, there's a file that,
They're labeled.
they are, but you can't blame the person who's just like, where is it?
Oh, I know. I do that to Kelly all the time. I'm like, where the heck do you keep this?
Yeah, everybody keeps their own stuff in their own stuff.
I guess I might as well give this to you, James, since you're checking them in.
And then we'll have another round of hearings tomorrow afternoon, right?
Yep. I just have to sign that tomorrow when they arrive. Please.
Ready?
Yes, we have LT in the afternoon, because you know, it drives me crazy not to have anything happening all day. Although, we may still be doing this tomorrow.
The testimony that long.
Huh?
I was just saying, usually I'm happy to take advantage of having nothing.
Yeah, but our LT dockets are so backed up. I struggled during LT day to find places for things. So when I have an afternoon, plus every other ordinance day, we put LT in the afternoon. Clearly, it's the every other, as here we are. The other one, we put pure civil discovery, pre-trial, motions, and bench. I like to keep it mixed up a little bit.
Well, no, and we've got like places to put defaults and stuff. So
Otherwise, someone will get snappy that I'm having that pretrial slots, which,
And that's between him and Civil.
well, the pretrial form is just kind of silliness. Don't know yet, don't know yet, don't know yet, don't know yet.
I mean, I don't know, the discovery hasn't happened, it doesn't make any sense, but that's how they do it, so that's how they've done it, but you can't tell me your like interrogatory issues or this will be dismissed if you haven't had discovery, because all that who the experts are, who the, what your exhibits are, all that comes out of discovery. So
It's just.
really, it's just a premise for setting discovery. And then putting NA on a lot of the stuff like that happen. So it's not time consuming, but it's tedious.
I think that's just a civil case for 90-day out discovery. If they need more, that's when you have the hearing, that's when you do the
I
pretrial.
think you should do 90-day discovery automatically.
And then set the pretrial 90 days after, and we can address any issues that have come up in discovery and or if they need longer discovery. District court, they're not that complicated usually at this level.
The most complicated we've had has been the Woodhaven case. And that's because the amounts have been so extensive. I mean, when you get over 50 grand and you're in the rightful place, it's not like they're asking over 50. This is a compliance case. You got problems. And there's a case in Eaton County in circuit court. And there's a case in the Federal Western District Court. And that might change it all, because if the Fed Western appoints a receivership for Woodhaven, then I'm asking the receiver for money. The city's asking for the receiver for money, and that takes place after the receivership's all set in stone.
We're never gonna get rid of this, are we?
That's what I'm trying to tell you.
I like it when you gentle.
I'm trying to tell you that
That box is gonna be getting.
I'm trying to tell you
The
that
box is moving with us.
it's gonna be a long time.
That box will be at the new courthouse. Is that what you're telling me?
What you don't want is that big apartment complex just to sit there empty.
Yeah.
And it's just a blight in the Lansing community. That's what you don't want. But 60 units at 500 a pop that's
I have to have a chat with my dog tonight about stunts.
I don't know if that's going over that well.
Perhaps he needs some flashcards.
Yeah, perhaps he's a dog. Dogs like skunks, certain dogs.
He looked at me like he understood everything completely.
Well, that says more about you than it says about the dog.
It was a very long day, Judge.
Mr. Bach, you got about 7 minutes from Ms. Sykes. Nope.
Which is good because I need to get money.
There was a judge in Jackson, Judge Phillip. Know him?
No, the district court judge.
Tired.
Because I know they appointed the new district court judge pretty fast.
He didn't have a 15-minute.
He didn't?
He had a 1-minute rule. I fell victim to that one time because I was in the hallway talking to a different.
Yeah, that's I think 15 minutes is about fair. Yeah.
What we got in college.
I would just be removing warrants if we did the 1-minute rule. That's all that would be.
It's just more work because then you're moving aside, you're setting aside all the stuff that you were impatient for before.
I have to say though, that was the most fastest efficient courthouse of all courthouses. In all of them,
Everybody was on time, huh?
Well, that, and I can remember parking the car with judgment in hand in like 5 minutes.
Really?
Where was this? Jackson, fastest courthouse in the land.
That was pre the new district judge.
Well, yeah,
Things have
this was
changed.
back when I was only doing coverage.
You know how they do first Zooms in Novi? They have, and it doesn't matter whether it's Reeds or Law or come on, what's his name? Travis Reeds. Yeah, blanket on his name. He's the most entertaining of the three of those guys. But anyway, they set them all at 1 o'clock. You know, so they got like 40 or 50 cases. They read them their rights once. They play this droney video that everyone plays. And then it's like they call a case and they give them a hearing date. They call a case and give them a hearing date. And they go bang through like 40 or 50 cases in an hour and a half.
Do they let anybody meet? Like, do you meet
No.
to talk about? No,
No,
they're not interested in that.
And then when you come back for the second hearing, they're not putting people in breakout rooms or anything. You come back for the second hearing, it's like, do you agree with the amount? Yes. Okay. Judge, what's the plan? They just crank through.
Oh,
I mean, well, the thing is,
they have volume.
they have volume
Yeah.
and they got 3 judges and they keep it. I mean, they're keeping it up to speed.
Yeah.
So we have a consent judgment.
You've got a consent judgment ready?
Yeah.
Gonna put that on the record?
Yeah.
All right. That's Miss Black, is that correct?
Correct.
And then Miss Beard, you're gonna, that case was the other one that's already.
LG Park Place is dismissed.
Okay. All right, so we're on the record in a docket 2403142. That is for 2 REO Gateway LLC versus Diane Black. Will the parties please introduce themselves to the record? Mr. Whitty.
Good afternoon, Your Honor. Norman Whitty, appearing on behalf of the plaintiff, REO Gateway LLC.
And ma'am, you are Diane Black, is that correct?
Correct.
Thank you. This is a time set for a landlord-tenant hearing, and we previously met on July 17th. All parties appear. There was some talk with legal services, and Ms. Black, you've indicated today that that they're questioning the notice of legal services, but they told you that you were not represented today by legal services. Okay. And Mr. Whitty, you haven't had any contact with legal services, is that correct?
I have not.
All right. Mr. Whitty, how are we proceeding today?
Your Honor, the parties have agreed to a consent judgment in this case. I think those terms on the record, if I may.
You may.
There's currently rent to retain due in the amount of $7,636.66. Court costs are $232.61 for a total possession judgment in the amount of $7,869.27 to be paid on or before September 6, 2024. We also requested a money judgment in this case. The prorated rent through today's date for the damages is $7,507.76. Court costs $232.61. Total amount of the money judgment, $7,740.37. I did go over Ms. Black's rights under MCR 4.201J with her. After discussing those rights, she signed the consent judgment, if I may approach.
You may. And Ms. Black, was there anything different that you agreed to with Mr. Whitty that he did not indicate on the record?
I don't believe so.
Okay. And you understand that the court rule indicates that you have 3 days from today's date, because you were unrepresented, to sign this document from the day's date. So 3 days from today's date to indicate that what we did here was vague or ambiguous, or you didn't understand.
Okay.
Do you understand that, ma'am? All right. The court rules have been explained. You signed the bottom of this?
I did.
All right. I'm in possession of the consent judgment based on the terms placed on the record in box 1 and 2. 4A is checked. The plaintiff can apply for an order evicting the defendant. The defendant does not pay the plaintiff or the court the amount due in item 2D above, or does not move out on or before September 6, 2024, which is the same date as the appeal date. 5 and 6 is checked. A 6 is checked. Partial payment will not be accepted, and a money judgment also is being requested for the prorated amount. I will sign the document at the request of the parties. So that's 8. We will sign the original in. and I think you'll get a copy from the original. Anything else for the record in 2403-142, Mr. Whitty?
Nothing further, Your Honor.
Ms. Black, do you have any questions of me?
I guess I'm a little confused about one point, and it didn't hit me until now. It doesn't make mention that I did agree to make payments toward that amount to work out a payment plan.
As long as it's all paid by that September 6th date, is that correct?
Oh.
We were discussing the possibility, and I want to be clear about this, about some sort of payment plan on this. And I highly encourage her to communicate with my client and to make some effort on payment plans. Obviously, she does that. It's more likely that she'll eventually A, get this paid off, and B, not have it sent to a collection agency.
Right.
But the problem is right now her income is kind of variable, so we really can't sit down and say, this is a final payment plan that's going to take this out and, from cradle to grave and get it paid off. So there's going to be a requirement that the parties have some communication and come up with something as her financial situation improves.
Right. So the writ date is September 6th, but you're speaking with the property manager. That might change that date, but that is the date that you've agreed to.
Well, it won't change the move out date.
Right.
It'll change
I
what happens
agree
with,
to leave.
yeah,
Okay.
it'll change what happens with regard to the money judgment.
Okay, all right. And the money judgment, all those terms are placed on the record.
Correct.
All right. Any other questions, Ms. Black? All right. You can get a copy of this for your records and we'll scan it in for our own records. Thank you for your appearance for everybody.
Thank you.
All right, thank you.
All right, and then
copies on it. I'm just trying to make the record. Have a good day, Your Honor.
you too.
Bye-bye.
We'll see you, Ms. Black. Thank you for your appearance.
Thank you.
I think you last but not least, Mr. Bach.
I'm last of the day?
You are last of the day.
Oh, man. Well, I'm so happy to not be going through pictures and text messages.
Yeah, well, that would make two of us, Mr. Vaughn.
I had to do that in this courtroom with,
I know, we've done that.
who was in here before? Was that with you?
Yes.
Oh, that was,
We've gone through texts and
that was a
pictures.
messy little one.
Yeah.
For sure.
Every once in a while, you just have to do what you have to do, you know?
We were here till a little after 5 that day.
All right, so we're on the record in docket 2403-133, REO Vincent Apartments versus Rachel Sykes. Will the parties please introduce themselves for the record, Mr. Bach?
Yes, good afternoon. I'm Ronald Bach here for plaintiff REO Vincent Apartments.
All right, this is the time set for a landlord-tenant hearing. This is scheduled for 3 o'clock. It is now 3:18. The parties all met previously on July 17th, and this formal hearing was set. I have, and Miss Sykes, it's actually S-Y-K-E-S. She indicated her name was Sykes, which is what we have now, Rachel Sykes, S-Y-K-E-S. This was set for 3 o'clock. It is now 3:18. I do not see a Rachel Sykes on the Zoom courtroom, physical courtroom, or in the hallway. Mr. Bach, how are we proceeding today?
Yes, I would request an entry of a default judgment, Your Honor. I just see the one supplied to me had the wrong case number. I had to verify I had the right one.
Are there any terms you want to put on the record for the consent judgment?
Certainly, at this time, rent to retain is $5,300, even with $179.08 in costs, for a total to retain possession $5,479.08. I've got a writ date of 9/6/24 as well as the appeal date of 9/6/24. There is no money judgment at this point. At this time, and partial payment will not prevent the court from issuing.
All right, and to the best of your knowledge, Ms. Sykes is not a minor incapacitated in the military service, and the premises was kept for its intended purpose.
Yes, sir.
All right, do you have an order to that effect?
Yes, may I approach?
You may. Thank you, Mr. Bach. So I'm in possession of docket 2403-133. That's a default judgment. Terms have been placed on the record. The box 1 is checked, box 2 is checked. for the total of $5,479.08 for his check with a writ date of September 6th. 5, 6, and 7 are checked. 6, except partial payment will not be accepted. And the appellate date is September 6th also. I will sign the document. I want to make sure. I keep signing the wrong date, which gives everybody a problem. Oh.
Well, you'll get the hang of it eventually.
Eventually, you would think at some
Still
point.
the new guy on the block.
So I will, the order has been signed and we'll provide a copy for your records. Anything else for the record in docket 2403133, Mr. Bach?
No, thank you.
All right, thank you. You're all set, Mr. Bach. All right.